Good evening. I'm Elizabeth Horner. I'm the Director of Education here at the Michael C. Carlos Museum, and it's my pleasure to welcome all of you tonight. I'd like to begin by expressing my warmest thanks to Lynn Kirkland, who's here with us tonight. Lynn endowed the Grace Welch Blanton Lecture Fund, which has made tonight's program possible. Thank you so much, Lynn, for being with us and for making this all happen. I also want to thank Ed Snow, the co-chair of the museum's National Leadership Board, and his wife Dina, for their graciousness, their generosity, and their commitment to building community on evenings like this when we welcome distinguished speakers to campus. In October of 2020, as we were getting used to Zoom and exploring all its possibilities, we at the Carlos were able to produce Mary Kathryn Nagle's powerful play, Sovereignty, reuniting the original cast from the Arena Stage production, 9 Native American actors portraying 13 roles, zooming in from cities across the country. It was something. The only way the Theater Authority, the governing body of the Screen Actors Guild, and would allow us to work with equity actors was to stage this as a fundraiser. They didn't quite know what to do with Zoom productions yet. So we staged it as a fundraiser, and those funds allowed us to hire a remarkable young woman, an Emory sophomore, Manahata horse, a citizen of the Comanche Nation, as an intern in the education office. And she has contributed so much for the programming for the Each Other exhibition. So it is my great pleasure to turn the podium over to Manahata to introduce tonight's speaker.
Thank you so much for that kind introduction, Elizabeth. I will be presenting Emory's Land Addressment. Emory University acknowledges the Muskogee Creek people who lived, worked, and produced knowledge on and nurtured the land where Emory's Oxford and Atlanta's campuses are now located. In 1821, 15 years before Emory's founding, the Muskogee were forced to relinquish this land. We recognize the sustained oppression, land dispossession, and involuntary removals of the Muskogee and Cherokee peoples from Georgia and the Southeast. Emory seeks to honor the Muskogee Nation and other Indigenous caretakers of this land by humbly seeking knowledge of their histories and committing to respectful stewardship of the land. Tonight, I am honored to introduce Mary Kathryn Nagle, an enrolled member of the Cherokee Nation and a partner at Pipe Stem and Nagle Law PC. She works to protect tribal sovereignty and the inherent right of Indian nations to protect their women and children from domestic violence and sexual assault. She's argued cases before the United States Supreme Court representing and advocating for Native rights, such as Adoptive Couple v. Baby Girl and United States v. Cooley. Mary Kathryn studied theater at Georgetown University before graduating summa cum laude from Tulane Law School. From 2015 to 2019, she served as the inaugural director of Yale University's Indigenous Performing Arts program. She has received commissions from Arena Stage, Portland Center Stage, the Denver Center for Performing Arts, Roundhouse Theater, Yale Repertory Theater, and the Oregon Shakespeare Festival. She is one of the country's most produced playwrights, having written 13 pieces, including Welcome to Tlamet, Manahata, Silver of a Full Moon, Father's Eyes, My Father's Bones, and Reclaiming One Star. Mary Kathryn also represents the National Indigenous Women's Resource Center, which supports ending violence against Native women. Before we begin our lecture, I would like to extend a personal thanks to Mary Kathryn. Beyond your play, Sovereignty, allowing me the opportunity to work at the Carlos Museum, your dedication to art, advocacy, and law has helped create a space for conversations like Safety for Our Sisters, Ending Violence Against Native Women. And I'm proud to not only say that I'm the first in my family to receive a college education, but I'm able to do it in a space dedicated to the acknowledgement and reclamation of my people's history. Thank you.
Okay, this is working. Great. Thank you so much for that incredible introduction. And I am very honored to be here tonight. Is that too loud? I don't know if that's not too loud. Okay, great. It's so strange to be talking with a mask on, but it's just nice to be back in person. I've missed it, and I think we all need that community and to be together. So thank you so much for having me here tonight. It's a huge honor and a blessing to be able to share this space with you all and to have this conversation. That was such a lovely intro. You really did your research on every single little facet of my career so far. And I will say that it's always a special treat to come home to Georgia. I am a citizen of the Cherokee Nation. My Cherokee Nation historically was in northern Georgia, southeastern Tennessee, western North Carolina, even western parts of South Carolina, and even some of our hunting grounds were in Kentucky and very southwestern Virginia. So we have a very expansive area that we claim as our ancestral homeland. But prior to our forced removal on the Trail of Tears, my family actually lived in Rome, Georgia. And so, and their homes are still, some of them still standing today. In fact, my great-great-great-great-grandfather's home is a museum there in Rome. And so as a kid, we would, my father would pack us up in the car and we would take my grandma and we would drive back to Rome, Georgia for spring break and, take my grandma to see our family's homes. And New Echota was our capital before Georgia passed a law making our capital illegal and our government illegal. And then of course we had to move it to Red Clay, Tennessee, just across the border. But coming home to Georgia is always a very special treat, and very much appreciate the land acknowledgement statement. Of course, Cherokees and Creeks, I think over time have disputed who gets to claim Atlanta, but my husband is the ambassador of Muskogee Creek Nation. And so I have to respectfully let Muskogee Creek Nation claim Atlanta. But actually, all joking aside, I think that I think no university or institution should ever be criticized for doing a land acknowledgement statement. Our Indigenous nations, just like many other nations, have borders that are not stagnant. And honestly, we didn't really even have borders so much like we think of borders today. And so our ancestral homelands often overlap, and it's creating a 100% accurate land acknowledgement statement that everyone is going to agree on is actually an impossible task. And whenever people ask me to help them with a land acknowledgement statement, I always bite my tongue because it's like, which tribal nation is going to be angry about this statement? So it's a very daunting task, but I think the goal is to acknowledge that these lands are ancestral homelands of a tribal nation that's still here today, and that reality commands our respect. And so that's wonderful. Let's see. So tonight's topic, safety for our sisters, ending violence against Native women. A lot of the work that I do, both as an attorney and as a playwright, is focused on the issues related to violence against Native women. And so what do I mean by that? Well, we can, interesting, that did not move it over. Oh, okay. Oh, and that did. Fantastic. Okay. So there are lots of facts that we can throw out there, right? 96% of American Indian and Alaska Native victims of sexual violence experience violence by a non-Indian partner, while only 21% experience violence committed by a Native partner. So we know that the violence that we're talking about is interracial in terms of there is a good deal of non-Indian perpetrated violence against our Native people. Native women are murdered at a rate of 4.3%, while white counterparts experience homicide at a rate of 1.5%. 4 in 5 Native people report having been victims of violence, and 56.1% of Native women report being victims of sexual violence. Now, these are all statistics that come from the United States Department of Justice. And I think too, the reality is that many of these statistics are actually understated. because we have a lot of distrust in our tribal communities for law enforcement and authorities. A lot of times, and I'll get into it, but you know, the actual jurisdiction and authority of our local tribal government to protect us has been stripped away in many instances by the US Supreme Court, leaving in many instances only the federal government to protect us. They often don't show up when you call them for help. A lot of Native victims simply do not see the purpose of calling law enforcement and actually understand that to be imposing an even greater risk on their own lives. And so a lot of these statistics are understated because a lot of Native victims simply don't report the abuse or the violent crimes that they endure. I know that in a lot of tribal communities, aunties and mothers are telling their young girls not how to be aware of, you know, a potential rapist within the community or on tribal lands, but telling them that when they're raped, here's what they need to do. And that's a really sad reality in a lot of our communities, but especially on certain reservations, there are a lot of non-Indian criminals that know they can go on to tribal lands and rape a girl or woman with impunity because the tribal government will not have criminal jurisdiction over that crime. So it is a crisis. It's a huge issue that we face in Indian country, especially when you think about the levels of intergenerational trauma from forced removal, from the forced taking of Native children from their homes to boarding schools where many kids were sexually abused. And then you add on this legal jurisdictional issue today where basically Native people are we're like the one segment of the United States population that doesn't have a right to be protected by our own local government in our own homes against any person who comes into our home to commit a crime. And that's a problem. I also do a lot of work on the missing and murdered Indigenous women and girls crisis, or missing and murdered Indigenous persons, to include our two-spirit relatives in that. And there's a lot of data out there that the Urban Indian Health Institute has put out on the levels of violence that Native people face when it comes to murder. The NCIC, which is a national federal database that the Department of Justice hosts, shows that in 2016 alone, there were 5,712 reports of missing American Indian and Alaska Native women and girls filed, but the DOJ's federal missing persons database only logged 116 of those. So it's a huge crisis. A lot of times when a Native girl or woman goes missing, the family will report that to the local federal or state authority that has access to this national criminal database. And the federal or state authority won't actually log the missing persons report into that national database. Oftentimes, Native families are told, well, it's not a crime to go missing. She'll show up again sometime. She doesn't, right? She's been murdered or sex trafficked. They're told, well, you know how these young Native girls are, implying that, they've obviously called this upon themselves because of some choice they've made, which is ridiculous. And there are many excuses that blame the victim, and we see very little action from law enforcement to actually try to save the life of a Native woman or girl when she goes missing. On some reservations, the rate of homicide of Native women is 10 times the national average. And, in many states, actually, where does that, that's interesting. Okay. I think that statistic was supposed to come out of Wyoming, and that's not very clear, but Native women make up just 3% of the state population, but comprise 30% of all missing persons. And we were doing a lot of this statistical analysis when the very tragic death of Gabby Petito took place, her homicide, in the state of Wyoming, at the national park that she was visiting with her fiance, who is a suspect, I understand, in her homicide. Her death is horrifically tragic, and our hearts go out to her family. But the FBI showed up, and they showed up in force, and they showed up they brought all the resources they had to bear to find and locate her and to investigate her homicide. in this same state where she was murdered, 30% of all missing persons are Native, and yet Native people only make up 3% of the state's population, and the FBI does next to nothing about those cases. And I know because I represent a lot of families who reach out to me because they want a lawyer to help them. They don't know what else to do when law enforcement ignores them and won't talk to them, won't interview them, won't treat the fact that their loved one is missing as a crime, or when their loved one is murdered, they won't treat that as a crime. So we really have a huge crisis on our hands. I like to, I talk a lot about data, but I think it's important to understand that these are real lives, right? These are real women. These are mothers, these are daughters, these are our sisters, they're our nieces, they're our aunties. And each life that's lost is a tragic loss. So I'm just gonna go through a few cases. I don't have time to talk about all of them. Savannah Greywind, some people do know of her case because it is what inspired the federal legislation that resulted in Savannah's Act, which was signed into law by President Trump in October of 2020. Savannah was 22 years old and 8 months pregnant when she was killed in August of 2017. Her baby was literally cut out of her womb and her body was dumped in the Red River. Now, horrific case. Her child did actually survive. Her case is actually unique in that ultimately the authorities did arrest and prosecute the two individuals who murdered her, Brooke Cruz and William Hone. And that's like an anomaly in Indian country when a Native woman is murdered for there to actually be a criminal investigation and a prosecution. But I think what's important about Savannah's case is that the local authorities searched these individuals' apartment. Okay, there was blood everywhere. They had literally cut a baby out of her womb. They had the child. And the law enforcement authorities searched these people's apartment like once or twice, and they're like, nothing to see here. And they lived in the same apartment building as her. And they refused to search for Savannah's body until finally her family formed a search party and helped locate her body in the river. That was not a law enforcement effort. And this is the reality for so many of our Native families, that when someone is murdered in your family or goes missing, our families are our first responders, our families in the communities. And this is this is off tribal lands. This was in Fargo, I believe. But on tribal lands, off tribal lands, unfortunately, it's our Native families who have to be the first responders and who have to search for our women and girls. Olivia Lone Bear is another horrifically tragic story. She was a 32-year-old mother of 5, and she disappeared in October of 2017 from Fort Berthold in North Dakota. And if you know anything about Fort Berthold in North Dakota, it's a part of the Bakken in western North Dakota, has extremely high rates of oil extraction. It's actually where the Dakota Access Pipeline sources its oil for that pipeline that the Standing Rock tribe and hundreds of other tribes opposed in the fall of 2016. And there's been a huge proliferation of man camps on that reservation, the Fort Berthold Reservation. Over hundreds of thousands of men who work in these oil camps and these oil extraction areas have moved into North Dakota and lived in these man camps. And the stories coming out of there are horrific. You've got tribal law enforcement officers finding naked children running down the highway because they've been kidnapped and sexually assaulted and then put out on a highway in the freezing cold temperatures naked after they were raped in these man camps. We have Native women who are being sex trafficked out of there. It is a horrific crisis. Olivia goes missing in the midst of all of that. You have the U.S. attorney who served in the Obama administration saying publicly that the human and sex trafficking in Western North Dakota, especially of Native women and girls, is off the charts. And the federal and the FBI, in response to Olivia's disappearance, was, well, she'll come back. She probably got mad at someone and probably ran away. And she was a mother of 5, and her brother was in the media pleading law enforcement to dredge all the lakes. There are several lakes because the Army Corps has dammed the Missouri River that flows through their reservation. Matthew Lone Bear was on the TV writing letters to the FBI, asking senators to call the FBI, begging for the FBI to investigate and to search the bottom of these lakes that are on their reservation. Finally, some volunteers got out there and actually found her truck that she had. This was like 10 or 11 months after she'd gone missing. And it was at the bottom of the lake, and she was seat buckled into the passenger side. Of course, at that point, the condition of her body had deteriorated so much being down there in the water that an autopsy is very difficult to do and really determine the cause of death. And the federal authorities have said the cause of death is undetermined. They won't say it's a homicide, and they're not doing a criminal investigation to determine how a mother of 5 who loved her children more than anything ended up seat buckled in a truck at the bottom of Lake Sakakawea on the Fort Berthold Reservation. Kisera stops pretty places. I actually represent her family, so I'm their attorney, and she was 18 when she disappeared in late August of 2017 from Hardin, Montana. Her body, so she disappeared on August 24th. On August 29th, her body was found in Hardin, Montana at a very busy intersection in a suburban area. And I've stood on that intersection and, you know, you can't go 30 seconds without a car coming by. And her body was found right in the corner of that intersection by an elementary school principal who lives in the neighborhood and goes jogging every morning. And he got up to go jogging that morning and saw her body there and called the police. The police said, oh, she died of natural causes. She just probably laid there and died because her time of death was listed as several days before that. She'd gone missing on the 24th. By the time her body was found on the 29th, it was badly decomposed. And so the law enforcement said, no crime here. Maybe she drank too much. Maybe she did some drugs and overdosed, and she just wandered into this yard and died. And apparently no one noticed her body for 5 days, which is insane. That's obviously not what happened. They kept telling the family that she probably took drugs. The toxicology report came back, no drugs in her system. They have never really investigated her murder because the local law enforcement there, Bighorn County, says, again, that it's undetermined because she probably died of natural causes from, I guess, laying in the yard for 5 days straight. It makes no sense. But all you need to know is that she was murdered right off. Her body was found half a mile off the border of the Crow Reservation. She's Crow herself and also Northern Cheyenne. And the FBI clearly has criminal jurisdiction to investigate the homicide of a Native person, of a tribal citizen, if they're murdered on tribal lands on a reservation. The FBI here has refused repeatedly to do anything for her case because they say, well, her body was found off the reservation, therefore we don't have jurisdiction. That's not true. The FBI certainly has the authority to assist in the investigation, just like they came down to Atlanta and assisted in the investigation of the child murders here in the 80s, which they obviously should have shown up way earlier than they did. It took them too long. But the FBI can go and assist. Now, they may not have the federal government may not be the sovereign that ends up criminally prosecuting the case, but it doesn't mean the FBI can't get involved. It doesn't mean the FBI can't do anything. And here, they're literally using the excuse that her body was found half a mile off the border as an excuse to do nothing. And they've done nothing. They have not even talked to the family. They haven't even had an interview with the family, which is like something you would just do initially when an 18-year-old girl turns up dead, missing, and you would investigate everyone who last saw her. You would do interviews. It's like criminal investigation 101, right? Her case is really tragic because there are eyewitnesses who saw her at like 2 a.m. the night she went missing, being chased down that road. And the authorities are doing nothing, including the federal government, doing absolutely nothing. So I talk about all this violence, and I think, to really step back for a second and understand Why do Native women face these incredibly high rates of violence in this country? And I think there's a lot of things to talk about. Obviously, we can talk about the fact that we have a historically, the United States has had a culture that celebrates violence against Native women. Christopher Columbus, when he got lost and showed up here, bragged in his journals about how many Indigenous women he raped and kidnapped and murdered, as did many of the men on his ships. So violence against Native women began in terms of a colonial force in 1492. The US government used it when my nation was removed from here, from Georgia and our homelands. On the Trail of Tears, soldiers in the US military raped Cherokee women. And that's not just an oral history that I grew up hearing. It's actually, there are US soldiers, Indian agents, who wrote that down, because there were some individuals who, even at that time, thought that that was a horrific thing. And so we have white men documenting this. It's not that I think Native oral history should be believed full-heartedly. I think it's just as accurate, if not more accurate, than what white men write down. But that's just to say that this is a very well-documented history. And the book that Sarah Deer has written, called The Beginning and End of Rape, does an excellent job of cataloging the different forms of colonial violence that has been used in an attempt to dismantle and extinguish tribal nations. Because tribal nations understand that connection between the sacredness of a woman and tribal sovereignty, that if you don't have women, you don't have a nation. You literally will not continue as a nation if you don't have women, because women, we are the ones who give life. And there are many critical roles for people in our communities, including men and including two-spirit relatives. But women give life. And so women are sacred. And when you want to eradicate a nation, if you eradicate their women, you're going to succeed probably in eradicating that nation. The US military understood that. So we've got a culture that celebrates violence against Native women. We've got a history of violence against Native women that's never been confronted or dealt with really in the United States. And then we also have a culture that erases Native people, right? So what do you do when the future Supreme Court justices, the future governors, the future lawyers, the future teachers go to school, and in their K through 12 education, they're basically taught that after 1900, Native people don't exist anymore. You wonder why no one bats an eyelash when Olivia Lone Bear is murdered, or when Sarah Stops Pretty Places is murdered. Well, most Americans have been taught we don't exist. So if you're invisible, it's not a problem when you're murdered. So the invisibility of Native people is something we have to combat in the United States. This is research done by Illuminative, a nonprofit that I sit on the board of and very much support their work. They're doing a lot of work to combat that invisibility of Natives in arts and culture. And so this statistic came out a couple years ago. And what's really exciting is that since then, we've got TV shows written and produced by Native people, starring Native actors. You may have seen Rutherford Falls. You may have seen Reservation Dogs with Sterling Harjo and Taika Waititi. It is a very exciting time to see Native stories being shared. And of course, I, as a playwright, am also really big on let's get Native voices onto the stage. Let's tell Native stories. Let's combat that erasure. And I don't have a fancy slide for it, but I will tell you that still to this day, the majority of theaters in the United States, Broadway, off-Broadway, you name it, around the United States, have never produced a single play by a Native playwright, just a single play. When my play Sovereignty was produced at Arena Stage, wonderful, that was in January of 2018. That was the first time that theater had ever produced a play by a Native playwright. I don't think they've produced a play by Native playwrights since that I know of. And so hopefully they'll do one again sometime soon. And not that they need to have a Native play in every single season. That's not the expectation, but my goodness, you should produce, I think, at least one, right? Like why are Native people just entirely erased from the American theater canon, right? Well, I guess we're not entirely erased because we are actually simultaneously being portrayed with red face. And red face is, today in 2021, there's somewhat less acceptance of it than just 5 years ago. But I can tell you, so an Octarune is a brilliant play by an African-American playwright named Brendan Jacob Jenkins. It's brilliant because what it does is it challenges blackface, and it really calls into question and makes fun of, and I think challenges in a very thoughtful, smart way, the way in which blackface was created as a performance in the United States to dehumanize Black people. But one thing he does is he inverts the blackface, and I think it's brilliant. He has Black people playing white people, and sort of in this play that is historically was designed to dehumanize Black people and Native people. But he doesn't inverse the red face for Native people. So when you go see the play, you still see a white guy with red face paint and a headdress, like bumbling around, speaking incoherently. And he's apparently drunk the whole time. He's like got a whiskey bottle or something. And several of us Native artists raised questions about like, what's the goal here of showing this red face? Like there's no moment where it's contrasted with a Native person on stage saying something intelligent or coherent, right? There's no authentic portrayal to compare the red face to say, oh, interesting, okay, this is what's not real. This is the dehumanizing trope that was created to dehumanize Native people, but this is an actual Native person. And when I saw an Octarune, the audience was all non-Native as far as I could tell. And certainly, we come in all shapes and sizes, Native people do. And we have Black Native people, Asian Native people, white passing Native people. And I certainly fit into that category. So there may have been other Native people in the audience with me, but I could not tell and I did not know. And watching the way in which the audience laughed every time the red-faced guy came on stage and stumbled and fell down and was drunk, I don't know what else to say except that I found it incredibly traumatizing and disturbing. And every single Native person I know who went to that show walked out crying, couldn't stay in the show. It's kind of hard to explain, but watching your people being dehumanized on stage is very troubling. Another show that has really gotten a lot of attention is Bloody Bloody Andrew Jackson. And that show originated at the Public, went on to Broadway and had a run on Broadway. And it sort of takes Andrew Jackson and makes him a sexy rock star. And I don't know why we need to make Andrew Jackson a sexy rock star, but someone felt the need to. And there's a lot of red face in this play. And there's actually certain moments where they do like this 10 Little Indian song, and it's supposed to be really funny. All the different ways Indians get killed. I know they actually make, I never saw it. I only read it. I couldn't stomach seeing it, but Joy Harjo, who's a very dear friend of mine, who is the first Native US poet laureate and who's Muskogee Creek, one of her ancestors who signed a treaty for Creek Nation was portrayed in Bloody Bloody Andrew Jackson. And she said it was so horrific the way in which they used red face to portray her ancestor that she actually had a physical reaction and walked out of the theater and vomited. So it's really problematic the way in which red face continues to be used in the American theater. And still to this day, I've heard that the Public Theater, which produced Bloody Bloody, has some plans to produce their first play by a Native playwright, but they have yet to. So when many Native artists came to the Public and criticized this, they said, this is dehumanizing. Like, you are literally, Andrew Jackson is the equivalent of Hitler over here. He promoted genocide. He's responsible for the death of how many Native people and, all these horrible things he did. How can you celebrate this man? We were told, the Native community, that this is just artistic expression and you can't censor artistic expression, and that we may not understand it, but this is humorous. It's not meant to be offensive. And so apparently we couldn't be offended because it wasn't meant to be offensive. a lot of problems to unpack with that, but one of my favorite responses to the public theater and other theaters in New York was, okay, look, well, first of all, I would say this. I would say, can you name me the first play that used red face in the United States? No, not a single white artistic director who was producing red face could tell me the first red face performance in the United States. One of the first that rose to national prominence was a play called Metamora in 1828, the same year Andrew Jackson was elected to be president. And his campaign, this is one of his speeches. Now, this is a speech he gave to Congress. He said, they have neither the intelligence, the industry, the moral habits, nor the desire of improvement, which are essential to any favorable change in their condition. Established in the midst of another and a superior race, and without appreciating the causes of their inferiority or seeking to control them, they must necessarily yield to the force of circumstances and ere long disappear. Basically, Native people are racially inferior and they shouldn't exist anymore. That was his mindset. That was his goal. That's what he sought to accomplish. And he, advertised that. I mean, he wasn't, there was no shyness about this, right? The American public elected him. This was part of his platform. This was part of his campaign messaging, was I will eradicate tribal nations, okay? At the same time that he's elected president, the most popular play on Broadway was a red face performance called Metamora. You can't disconnect those things, right? In order to have slavery, you've got to have culture, an American culture that accepts the dehumanization of the people who are enslaved. In order to have genocide, you've got to have an American culture that accepts the dehumanization of the people you're killing, right? And the lands and whose land you are taking. And that is what red face did. And I don't think that you can intelligently repeat that performance today if you don't understand its origins. It's not witty, it's not humorous. It's literally an unconscious, ignorant regurgitation of a performance that you don't even understand the origins of. So I'm not artistically interested in red face at all. And I question theaters who continue to do it, but refuse to produce a single play by a Native playwright. And I think the production of red face is a major reason why we still have laws on the books today that started with Andrew Jackson that limit the ability of our tribal nations to protect our own citizens and our own homes. I do think the performance of red face contributes directly to the incredibly high rates of violence that Native people continue to suffer today. This is a law that my great-great-great-great-grandfather helped pass. So my great-great-great-great-grandfather, that's 4 greats, was the speaker of our Cherokee Nation Tribal Council in 1825. His name's down here at the bottom, Major Ridge, right under John Ross, who was the president of the National Committee at that time. And this was under Chief Hicks. At that time, the Georgia Guard the Georgia governor instructed the Georgia Guard to rape Cherokee women. The idea being, these Cherokees won't leave. We want their lands. Gold has been discovered in the mountains in northern Georgia. We have got to get these Cherokees out of here. They're not leaving. But if we rape their women enough, maybe they'll leave. And so there was actually written instructions to the Georgia Guard to just go in there and just rape those women. And that's what they were doing. Cherokee Nation passed a law making it illegal for anyone to come into Cherokee lands and rape a woman. Didn't matter if you were a citizen of Cherokee Nation, the United States, France, Choctaw Nation, Vermont, New York, didn't matter. If you came onto Cherokee Nation lands and raped someone, you would be criminally prosecuted by Cherokee Nation. In 1978, so that was 1825, right? And of course, at that time, we had a Cherokee Nation Supreme Court. The state of Georgia didn't even have a Supreme Court yet. Fast forward to 1978, 180 years after my grandfathers worked on the law I just showed you concerning rape in Cherokee Nation. And the Supreme Court decides a case called Oliphant versus Suquamish Indian Tribe. Now, in Oliphant, the Supreme Court said that tribes cannot exercise criminal jurisdiction over non-Indians who come onto tribal lands and commit crimes. Pretty insane. Why did the court say that? Well, one thing they said is, quote, The effort by Indian tribal courts to exercise criminal jurisdiction over non-Indians is a relatively new phenomenon. Not true. Cherokee Nation had a court in 1825. Also, many of our tribal nations didn't have what you would think of as a Western court, but that didn't mean they didn't have tribal justice systems. They had clan systems, they had rules, they had laws in place to administer justice if someone in the community committed a wrong. And we didn't necessarily put people in jail, but we had ways of holding our community members accountable and administering a rule of law to make sure that people lived safely, right? This idea that Indian nations didn't have courts or didn't have systems of justice until very recently is just factually incorrect. The other thing that Chief Justice Rehnquist in writing Oliphant cited to was a decision called Johnson v. McIntosh, which is an 1823 decision. Here, Oliphant cites Johnson saying, quote, "Their rights to complete sovereignty as independent nations are necessarily diminished." What Chief Justice Rehnquist didn't quote, and if you go and read Johnson v. McIntosh, it says that the reason our sovereignty is diminished is because we are literally racially inferior savages and heathens who do not worship Christ. So I would say this is a problematic foundation for a Supreme Court decision today in the 21st century. I think we're further along in our American democracy than that. But Johnson v. McIntosh has never been overturned. It's still good law. And it's still being cited in cases like Oliphant, which are still good law. And very problematic. So these are just some images of my family. So on the left, you see John Ridge. He was my great-great-great-grandfather. His house that he lived in before removal is still standing in Rome, Georgia. And there you see he's buried in this is our family cemetery. It's a Cherokee cemetery in the very northeastern corner of Cherokee Nation in what today is Oklahoma. And next to him is Major Ridge, his father. And both of them were assassinated in June of 1839 because they signed our removal treaty. So that's the subject matter of the place sovereignty that was produced here at the Carlos in the fall of 2020. And but Major Ridge, who you see on the right, was my grandfather, my great-great-great-great-grandfather, who was Speaker of our tribal council and passed the law outlawing the rape of Cherokee women on Cherokee lands. And so I take it very seriously that, and in fact, my grandmother is buried just about 20 feet from there, and I will someday be buried in the same cemetery with my family. And I have made a commitment to fight to restore the jurisdiction that when my grandfather was Speaker of our tribal council, that we rightfully exercised. Because I think it's very clear that this loss of jurisdiction is directly impacting the levels of violence that our Native people experience. This is an example of a protest of prayer outside the steps of the Supreme Court. In 2015, Dollar General argued, the Dollar General case, if I can just briefly explain it, is a case where I filed a brief on behalf of the National Indigenous Women's Resource Center, my client, because in this case, Dollar General was operating a store on the Mississippi Choctaw Reservation in Mississippi, and they employed a student intern, a 13-year-old Choctaw boy who worked there during the summer as an intern, and he was sexually assaulted numerous times by the non-Indian store manager. And so if you remember Oliphant from 1978, the tribe cannot criminally prosecute that non-Indian because he's a non-Indian, even though he sexually assaulted a child within Mississippi Choctaw's borders. The sovereign that can criminally prosecute that is the United States Attorney's Office in Mississippi. They chose not to. More often than not, crimes committed against Native people are not a priority for the United States. They're more interested in drugs and terrorism and things like that. And those are important things to think about. But meanwhile, we're left unable to protect our children. And so the parents of this child brought a civil lawsuit because, mind you, Oliphant only dealt with criminal jurisdiction. They brought a civil lawsuit challenging Dollar General's supervision of its employees, saying, you, Dollar General, negligently supervised your employee because how the heck did this guy continue to sexually assault my child while he was working at the store? Like, you are not supervising your employee. This is a very vanilla tort lawsuit that, people bring in all jurisdictions across the United States, tribal, state, federal. And so they brought this case, and Dollar General's response was not like, oh, the sexual assault didn't happen or anything like that. It was actually, no, tribal court, Mississippi Choctaw, you do not have civil jurisdiction over me because I'm a non-Indian corporation. And we know from Oliphant that tribal courts have no jurisdiction over any non-Indian person or corporation. And this went all the way up to the Supreme Court. And that was actually Dollar General's argument, is they basically looked at the Supreme Court and they said, wink, wink, you did it for criminal jurisdiction in 1978. Now just take it all the way, take away civil. And this was a huge threat because the one thing we do have, right, Oliphant eliminated criminal jurisdiction over non-Indians, but we never lost civil. And so for our Native women who are in abusive relationships, because protective orders are considered civil jurisdiction, they could still go and get a protective order in tribal court. At least they could get that, right? There wouldn't necessarily be a criminal prosecution for violating that protective order, but you could at least get that protective order. These are all the amazing, we had Native folks, allies who traveled long distances to come to DC in December of 2015 and stand outside the Supreme Court and pray for the right outcome. I was there for the oral argument. It was very disturbing. Dollar General's attorney got up and literally said that tribal courts cannot be trusted to provide due process. And that basically we should assume when a non-Indian goes before a tribal court that due process rights will be violated, even though that attorney had no examples of a tribal court actually violating the due process rights of a non-Indian defendant, like Dollar General or a human being. And I think what is really striking about all of this is I think any person of color knows that if you just point to any state court, well, especially some specific state courts, but pretty much anywhere in the United States, it doesn't have to be in the South. I think as we're learning from recent trials, there are due process rights violations for people of color in state courts all the time. I mean, we've got several states who have literally put people of color to death for crimes that we later found out they didn't even commit. And no one, the Supreme Court's not thinking, oh, we should take away this state's criminal jurisdiction, right? Tribes don't even have to violate due process rights. And corporations are going to the Supreme Court saying, well, we know Indians can't be fair, wink, wink. So we know due process rights violations are going to happen. Just take away their jurisdiction. It's pretty outrageous, I think, that anyone would make that argument. And thankfully, this is another photo from that amazing protest. But thankfully, the case was argued, and it was very clear that we were going to lose 5-4, just based on the questions the justices were asking. And that was very disheartening. And that was argued in December 2015. And then in February 2016, the case had still not been decided. And Justice Scalia passed away. And he had been one of the justices against, very clear in the questioning against tribal jurisdiction. And so it came out in June of 2016 as a 4-4 tie. And they wouldn't tell us which justice voted on which side, but you can probably guess. Okay, I'm really going long here, so I got to speed up. Okay, so I mentioned that Oliphant took away criminal jurisdiction in 2013. The Violence Against Women Act, which was signed into law by President Barack Obama on March 7th, 2013, and restored tribal criminal jurisdiction over non-Indian perpetrated crimes of domestic violence, dating violence, and violation of protection orders. Huge step in the right direction. This is on the far left, Diane Millet, who is Southern Ute, who was invited to introduce the president at the signing. It's a very amazing historic moment for all Native people. And standing next to her is then Vice Chairwoman Deb Parker of the Tulalip tribes. And it was just an incredible historic moment to have these two amazing Native women survivors, both of them survivors, on stage to introduce the president for the signing of that bill. So that's VAWA. And if you understand the significance of this restoration of tribal jurisdiction and sovereignty for us to protect our own women and children, you'll understand where I'm going with my place sovereignty and the stories I'm trying to tell. And so, you know, I will say just for a moment, we're working on VAWA 2020-21 now. And VAWA should have been reauthorized in 2018. And we've had a lot of roadblocks trying to get it reauthorized. HR 1620 did pass in the House. It was a bipartisan bill. And we're now looking to get it through the Senate. And we've been hearing for quite a while now that there's a bipartisan bill that's being worked on, which we're very excited to hear about. And there may be a hearing scheduled sometime very soon. So stay tuned on that. And so we're very hopeful that a bipartisan VAWA will be passed that restores additional categories of tribal criminal jurisdiction over non-Indians. Because if you understand what has been restored, domestic violence, dating violence, violation of protection orders, doesn't cover child abuse, doesn't cover rape, like stranger rape, which happens a lot on our tribal lands, doesn't cover human trafficking, a huge issue in Indian country. So all these non-Indian crimes, basically, if you're not in a domestic relationship, then there's no tribal criminal jurisdiction if the crime is being committed by a non-Indian. And it still leaves our people very much unprotected. So we're really hoping to secure the passage of VAWA with additional restored categories of criminal jurisdiction. So I have sought in my plays that I have written to talk about these legal issues and to humanize Native people for audiences who probably have never seen a play by a Native playwright or actually seen an actual Native character. Now, of course, the film and TV strides that we've made with the shows that are coming out are really exciting. But for our theaters too, right? Like they're almost falling behind now because most theaters still have not produced a single play by a Native playwright. This is a photo of Sovereignty from when it was produced at Marin Theater Company in the fall of 2019, kind of before the massive theater shutdown with COVID. And this is a moment in the play where the young descendant of John Ridge and Major Ridge, the main character, is arguing in front of the Supreme Court in a hypothetical case, arguing for the constitutionality of tribal criminal jurisdiction over non-Indians as restored in VAWA. And behind her are her ancestors, my ancestors, Major Ridge, John Ridge, and Elias Boudinot. So I love that shot. This is a photo from the production of Sovereignty at Arena Stage in DC. And this is actually the moment where Andrew Jackson on the left, President Andrew Jackson, meets with John Ridge and Major Ridge, my grandfathers, and notice the difference in appearance, right? If you compare this with the image we saw from Bloody Andrew Jackson, which had white guys wearing like weird Halloween costumes, or it looks like what some fourth grader made for, a weird Thanksgiving celebration. That's problematic. It's like total joke, right? And this is what they actually would have looked like. And in fact, this is similar to the clothing they would have been wearing at the time when they met with the president. And my grandfathers met with the president on numerous occasions, as many, Comanche nations sent their leaders to meet with the president. You name the tribal nation, we have a sovereign to sovereign relationship with the United States. Our leaders have, since the United States came into existence, consistently met with presidents of the United States. Actually, Ruth Bader Ginsburg, Justice Ginsburg, came to the play at Arena Stage, which was really thrilling because, also at this point in time, we'd never had a Native law clerk at the Supreme Court. So at that moment, and Justice Gorsuch changed it and actually hired the first tribal citizen law clerk, which is really something that we now have had that. But if you think about the laws that the Supreme Court decides, right? If Supreme Court justices go to school and they're taught that Natives don't exist after 1900, and then they go see Bloody Andrew Jackson, and they never hire a Native law clerk, how do we ever expect Oliphant to be overturned, right? It won't happen. And so the fact that Justice Ginsburg came to the play is, if we can't get a Native law clerk onto the court, maybe at least we can expose these justices to plays by Native playwrights or to Native TV shows, So it was really exciting for her to come, and she wrote me the sweetest note afterwards, just remarking on how much the play had meant to her, and actually that she had lived out by Fort Sill, out in western Oklahoma, for some time while her husband was in the service. Okay. This is my play Manahata, which was produced at the first. This is the world premiere of the play at the Oregon Shakespeare Festival, and it's a play that follows the story of the Lenape in their ancestral homeland on Manahata Island, and sort of like juxtaposes the way in which the Dutch claim to have purchased the entire island from the Lenape for $24, which of course was not a legitimate purchase, but that's what they claim. They then built a wall to keep the Lenape out of their homeland. That wall became Wall Street, and that's where all these financial institutions exist today. And comparing that wall being built to kick the Lenape out of their homes with the financial meltdown in 2008, in which many millions of Americans lost their homes. And that's the comparison that Manahata makes. This is the land grab scene where the Dutch are purchasing the island from the Lenape. This is a scene where one of the main characters in the past, Liliwayu, has just witnessed the murder of her, basically her husband, the father of her child. And the sister's coming to get her and basically saying, we've got to run away, we've got to escape. Because at a certain point, the Dutch were one of the first to create the bounty system of awarding colonists a specific monetary award for bringing in a red skin, a scalp, or the skin of a native person they murdered. And so all of a sudden there were all these killings of the Lenape in their homeland because people were getting paid for it. This is my children's play, Return to Niobrara, and it was produced at the Rose Theater in Omaha, Nebraska in January of 2019. And it is a play that follows the story of Chief Standing Bear, who was a chief of the Ponca tribe. And after the Ponca were forcibly removed on their Trail of Tears, when his son died, he made his son a promise that he would bury his son in their homeland instead of in this strange new land where they knew no one. And so he walked 600 miles north in the dead of winter, broke the law, left the reservation to bury his son, was arrested by the federal government, was imprisoned. He then filed a writ of habeas corpus challenging his imprisonment, and the U.S. attorney at that time in 1879 argued that because the statute says all persons unlawfully detained, and Indians are obviously not persons, an Indian can't file a writ of habeas. And Chief Standing Bear actually won his case, and he made a very eloquent, powerful argument in federal court in 1879 in downtown Omaha, Nebraska, and basically said, I'm going to butcher it. I should have it memorized by now, but his point was, look, my hand might not be the same color as yours, but if you pierce it, I will also bleed. I will also feel pain. Like, I am a man. The same God made us both. And he made this powerful speech to the judge, and the judge declared Indians to be persons under the law. A very incredible, monumental case that most law schools don't even teach. This is my play, Crossing Minnesota, and it was produced at Portland Center Stage in April of 2019. And it's a play that compares and contrasts Lewis and Clark and the Army Corps of Discovery traveling up the Missouri River and crossing the Missouri River and basically kidnapping Sacagawea, with the Army Corps of Engineers granting permission to the Dakota Access Pipeline to also cross that same river, basically in the same spot. And so it goes back and forth between Lewis and Clark and Sacagawea. And then today, some of the teenagers at Standing Rock who really started the whole movement to protest the Dakota Access Pipeline. And this is my final shot. This is the very end of Sovereignty when it was produced at Arena Stage. The Jim Ross character and the Sarah Ridge Polson character taking the little baby boy Ridge back to the family cemetery. So I have gone over a little bit, I think, but hopefully we can still have a few minutes of questions, Elizabeth, if there are some questions. Yeah, thank you.
So while people are typing questions into the Q&A function on chat, I'd love to see if there are questions in the room.
Hi, thank you so much for being here. My name is Rachel Harmon. I'm one of the PhD students here at Emory, and my research focuses on human trafficking. So I'm obviously very interested in this topic, and I've previously worked as an anti-trafficking practitioner. So that's my background. The book you mentioned by Sarah Deer is one of my all-time favorites. So I had kind of a double question of number one, do you have any other like standout reading recommendations? And then secondly, what are some actionable things you would want people in the audience to be doing after hearing what you've shared tonight?
Oh, thank you. That's such a good question. I know I need to like write down my reading recommendations because people ask me this and I always feel like, wait a second. And then afterwards, I always think of all the books that I should have recommended. Anything by Louise Erdrich is amazing. And I think her book Roundhouse does an excellent job of really humanizing the legal reality of Oliphant. And so Sarah Deer's is like a nonfiction book. Roundhouse is fiction, but it really, I mean, but it's, you know, it's not like the story in Roundhouse is what happens in our communities. So that's a great book to read. Anything by Joy Harjo, I'm a huge fan of. Her book is, you know, she writes poetry and she has a memoir coming out. And gosh, I mean, there's so much good in terms of legal analysis. Walter Echohawk has a book called like the 10 Worst Indian Decisions. I think that's the name of it. That's a very good book. Anything by Vine Deloria. There's so many amazing Native scholars and Native writers out there. Suzanne Harjo is an amazing author, and her book Nation to Nation, which goes along with the treaties exhibit at the Smithsonian, is an excellent book to read. There are many others that I'm missing out here. And then, sorry, could you remind me what the other question was? Oh, right. Great. Thank you so much. I love that action. What can we do? You can call your senator, okay? And it doesn't matter if your senator is a Democrat or a Republican, right? Because we need bipartisan support on this. And we even though we might even think, oh, the Democrats are obviously behind this, it's not obvious because for whatever reason, when the going gets rough, a lot of times Dems will say, maybe we just put tribal aside and we get the rest of this done. Because there's a lot of really critical protections in VAWA for other communities of color, you know, transgender folks, two-spirit folks. Like it's a very critically important bill. But I think it's really important too for all senators to know, like you can't leave tribal out. We've got to have a tribal provision that restores tribal criminal jurisdiction. And we gotta pass it now. And I think for anyone who's comfortable calling your senator, writing an email, sending a letter, it's super helpful for them to hear from constituents that this is a very critical issue for them. And VAWA is happening right now, and it's an actual opportunity to restore additional categories of criminal jurisdiction. The other thing I think people can do is call your local theaters and ask them, have you ever produced a play by a Native playwright? And if their answer is no, then my goodness, like what are they doing? And for them, because I also have been told numerous times that part of the reason why our plays aren't getting produced is because there isn't much interest in them, which is crazy. And when my play Manahata was done at Oregon Shakespeare Festival, it was sold out every night, and that's not just because it's not about me, it's about our stories are powerful, and a good story is universal, right? Like I can see a really good story about a white person and appreciate it, just like a white person can see a really good story about a Native person and appreciate it if it's a good story. But there's this prejudicial idea that some people have that there's just not an interest. And I think and Hollywood does this too. And thankfully, Rutherford Falls and Reservation Dogs are going to break that mold. But you ask Sterling Harjo about the conversations he's had for the last 20 years. And everyone in Hollywood says, well, show me the example of where this worked before, where they want to, like, is this like House of Cards or Game of Thrones, or, show me the model for how this show will be successful. Oh, there is no native model because no one's ever done it before, so we can't do it. And so people in the entertainment industry need to hear from the consumers in the entertainment industry that we need Native people to have a voice, right? And I think that will go a long ways in making a difference too. And the other thing too is that it's really amazing when high school teachers and college teachers, and teachers in colleges and high schools teach plays by Native writers or books by Native writers, right? Like Joy Harjo's poetry. But when let's say these major theaters still aren't producing Native plays, but if teachers can teach Native plays to those students, someday those students will go and that generation will be running the American theater, and they will have read a Larissa Fastor's play, or they will have read a Madeline Sayet play or a William Yellow Robe play. And they will say, wow, let's produce one of those plays. I read it in college and it was amazing. So.
I have a question.
Yes.
You said briefly about a case that isn't taught in law schools. And I'm wondering if you can say a little bit more about how much of tribal law is taught in law schools, and what would you like to see? How would you like to see that change? What needs to happen, and is it happening?
Yeah, so most law schools do not teach federal Indian law. And I'll let them explain why, but so my play Sliver of a Full Moon is a VAWA play. It's all about VAWA. It features, in fact, who you saw in the photo from the signing, Diane Millet and Deb Parker. They're both characters in Sliver of Full Moon. It's all based on real life interviews I did with Native women survivors of domestic violence, attempted homicide, and sexual assault. And so, they're all, with non-Indian perpetrators where they couldn't get justice, right? Because their tribe couldn't prosecute their perpetrator. And VAWA makes a huge difference for them. Well, in telling that story, we talk about Oliphant because, you have to explain why. For a lot of people, they're like, wait a second, but why can't your nation protect you? You live within your nation's borders. It's like, well, there's this Supreme Court case. We did that play at Stanford Law School, Yale Law School, Harvard Law School, NYU Law School, you name it, the law schools, all these law schools. Every time we did it, all the students in the audience would be like, wow, like I'm a 3L, I'm a 2L, I'm a whatever. No one's mentioned Oliphant to me before. None of my professors have taught Oliphant. How can this be that there's this super problematic case from the Supreme Court that we're not talking about? And yeah, especially if you look at Yale, Harvard, Stanford, NYU, those are the schools that are producing the future Supreme Court justices and the Supreme Court law clerks. And they don't even read Oliphant or talk about it or study it. And then it's really problematic. And so we're using theater to educate in ways that law schools are failing to do so. And I think that law schools should teach federal Indian law. I think it's critically important. I think the United States wouldn't exist if it hadn't signed treaties with hundreds of tribal nations to gain sovereign authority over the lands that now comprise the United States. And the US Constitution says those treaties are the, quote, supreme law of the land. And federal courts decide a lot of Indian law cases, including the Supreme Court. How is that not something that's taught in law schools? I mean, the reason it's not taught is because it's not valued, right? For the same reason that most K through 12 curricula teaches kids that Indians don't exist after 1900, right? We're still invisible. And so that invisibility pervades all aspects of American life, including our law schools.
Thank you, Mary Kathryn, so much for being with us tonight. Oh, you have a question? Oh, sorry, Megan.
Yeah, thanks for this talk and for all your work. So your mention of the relationship between women, the sacredness of women and tribal sovereignty is such a powerful message. And I'm also wondering if you could think about sort of the ways that people are trying to use the legal system to also try to challenge tribal sovereignty, and maybe and the ways that you're working against that and other people are working against that as well.
Yeah, so that's a huge issue right now. In fact, my sister has a podcast called This Land, and the second season is dedicated to unearthing everything that's going on in the legal fight against the Indian Child Welfare Act. And that is I highly recommend the second season of This Land. I think it's very disheartening to see the amount of money being pumped into dismantling the Indian Child Welfare Act and to honestly trying to destroy tribal sovereignty. Our children are also the future of our nation. That's why the United States military and BIA took them away and put them in boarding schools designed by, someone from the US military, Colonel Pratt. I think that what is happening right now is, a lot of you is also reflective of the larger American political landscape, right? A lot of the strategists who are attacking tribal sovereignty are also attacking affirmative action, right? Attacking a lot of the laws that we put into place in the 70s and the 80s and 90s to achieve progress, really, and to achieve better equality in this country. And they're coming about it in a very this narrative that this is whatever you're wanting to attack, right? This constitutes racism against, in the Indian Child Welfare Act, it's like basically white adoptive parents who want to adopt Indian babies, right? And so it's really something to be concerned about. And for tribal nations, I think we have a long fight ahead of us, and I think the Brackeen case will likely go before the Supreme Court. And I think what my sister's podcast does such a great job is explaining who the people are that are funding this litigation and what their real interests are. And I just think that's important journalism. It's important to know that.
Hi, thank you. It's such an honor to have you here. I teach at Emory, and my students are really inspired by your work, like both the legal work and the playwriting work. I have a very practical question. Well, one question is, how the heck do you do all this? But you just do. But my practical question is, so my students read and/or watch when we got to have the performance at Emory, your play Sovereignty. And I'm wondering if the scripts of some of your other plays are also like available for purchase as scripts in the way that the Sovereignty script is, or not, or if they might be anytime soon.
So it's a great question. So Sovereignty is available for purchase. It's Northwestern Press, University Press has published it. My other plays, it's been very frustrating. Like, we have really struggled to find a publisher that will publish them. My agent thinks he has found, because I'm not joking. I probably get 2 or 3 emails a week asking for either in a college course or a high school course to teach one of my plays, and that's thrilling because, that means that the story is going to get shared. And so I'm sending, the PDFs out right and left. And it's just frustrating because the publishers are like, TV and film is starting to move this way. And the American theater, we've got theaters that are starting to produce Native plays. The publishers are like sitting over here in the 1800s or something. I don't get it. They're like, well, we don't have the data to show this will have enough sales to and it's like, well, yeah, because if you've never published Native plays before, you're not going to have that data. But we're sort of hopeful that we found a publisher. And so I actually just spoke to my agent last week, and it's just everything with COVID has been slowed down. And so I'm very hopeful that some of these other plays will be published soon. So thank you for that. And in the meantime, I'm very happy to share them for free. Because to me, it's just important that the stories get out. So thank you so much.
Okay, thank you all for coming. One more. Okay.
No, sorry. Well, you did a good job tonight. I appreciate it. It was very educational and engaging. I just got a quick question. What helped you realize that you didn't have to choose between law and creative arts, and that you could pursue both?
That is such a great question. So, I still battle that every day of my life right now. It was a very real decision when I was in college and I was trying to decide what to do with my life, which that's not the right way to look at it, because you have your whole life to every day you go to bed and decide what you're going to do. It's not like, oh, I'm going to be a lawyer. That's it. I have, no other options. I'm just being a lawyer. You can do anything at any time. You're not limited once you make a choice in life. But I saw it as like one or the other. And I decided to go to law school, and I felt kind of heartbroken about that because I love the theater, but there was no way. I was like, there's no way. I'm, put aside the fact that Native plays don't get produced, like just even if you're, Mr. white guy, heterosexual, waspy wasp, like, it's still hard for them to get their plays produced because there's just thousands of playwrights out there, if not, I don't know how many. And there's just a lot of competition. And so I just didn't think it was realistic that I would be a professional playwright. So I chose law school. I also really wanted to be a lawyer. I went to law school at Tulane when Hurricane Katrina hit, and ended up writing plays with our community that helped us all process the insane trauma of the hurricane and everything that had happened. And everyone got so excited that I started writing and producing plays in law school. I then went and clerked for the federal district court in Omaha, Nebraska, where the trial of Chief Standing Bear took place, and convinced the federal judges I clerked for to let me write and produce a reenactment of that trial that we did on the 130th anniversary of the trial in the courtroom. I just kept writing plays while I was being a lawyer, and I kept thinking, well, but see, those examples I just gave were not professional equity theater companies producing them. So I still didn't think that I would be a professional playwright. I was doing it as a hobby. And it wasn't until I went to work at a firm in Manhattan in New York, and I was encouraged, someone said, the public theater has this emerging writers group, you should apply. I did, I got in, which was crazy, that I really realized I'm doing both professionally at the same time. And it's crazy in terms of time management. It's very challenging, but I have a lot of people ask this question, right? Because a lot of people have multiple talents, right? And especially like you look at attorneys, good attorneys are good storytellers. And there are a lot of attorneys that are writers. They write poetry, they do photography, they write plays, they write novels, they, whatever, like they sew, they make pottery. I mean, and I just think that, I encourage people to not limit themselves. And I have found that my work as a playwright actually really complements my work as a lawyer. It's very challenging to figure out priorities and get the to-do list done every day. But the actual writing and the actual work I'm doing, I think doing both actually, my work as a playwright makes me a better attorney, and my work as an attorney makes me a better playwright. And I really want to continue doing both as long as I can, as long as it's humanly possible, and would encourage anyone who feels that conflict to take a step back and realize that you might have to do some real thoughtful time management exercises, but that you don't have to limit yourself in life, and you don't have to just choose one or the other.
Thank you.
Thank you all, and thank you to those on Zoom. Good night.
Thank you.